Yes, thank you very much for the kind introduction, Kat. And I should say thank you to Kat and all the team at Sorainen for the kind invitation. I understand it's the first event of this size for the private wealth team at Sorainen, so it's a true honour to be joining you. Today is actually exactly a year from when the UK, London, went into lockdown because of COVID. And I was really hoping that by now, a year later, I would have been able to join you all either in Tallinn, Riga, Vilnius or Minsk. But unfortunately, I have to still be sitting at my desk in London and imagining to be with you in person. So I will imagine all of you 600 around the Baltics and Belarus. I understand from Carter, even beyond, we have some people joining from elsewhere in the world. So this is really exciting. As Carter mentioned, I'm a private wealth lawyer, as we generally say in the industry, and this has been my specialization for some years now. And in the UK, there's a long-standing tradition of private client advice, and clients, so entrepreneurs, business owners, have been used to for generations to taking such kind of advice. Why? There are a few reasons that people usually point to, lawyers point to. The two sort of easy examples I can give you is that in the UK, for instance, we have a concept which is called testamentary freedom, and there's no forced heirship rules. People can, generally speaking, leave their assets to who they wish, and so this leads more people than in other countries, especially continental European countries and possibly and the Baltics, etc., to actually write wills. So that's already one factor. And the second factor is that whilst the UK has, relatively speaking, lower taxes during lifetime, it has 40% inheritance tax. So the pressure is on to put in place planning for the for transfer of assets between generations. So there's really a culture in the UK to plan. And now, as Kat mentioned, I've been seeing this approach. If Inez, I can go on to the next slide. I've seen this culture spread into other jurisdictions, even jurisdictions which have fewer opportunities, perhaps in terms of testamentary freedom or taxes. Some jurisdictions have no inheritance tax, so that is perhaps not a factor, a driver for planning. But I see a lot more of an appetite for this kind of conversation, and a lot of my clients actually have very limited connections to the UK, but actually value the Anglo-Saxon approach and experience in advising on these kind of issues. And also some, might not have family members resident in the UK, but for instance, and I will get onto this later in the presentation, like to use common law instruments such as trusts because of the flexibility they allow. So what do families do, and what kind of conversations do we have with families? This is an expression that I hear time and time again here in the UK, which is a stitch in time. There's obviously a rhyme here, saves 9. So a repair, so sort of a small step done early, carried out earlier on might avoid a disaster further down the road. And I've really seen in recent years, clients become more willing and responsive to having these kind of conversations and put in place some planning when they're still relatively young and when their businesses are still relatively in their early day, because they realize that sort of protecting and putting something in place very early on could actually end up being more effective and potentially cheaper than waiting for a crisis point. There's a lot to be said about having those difficult conversations early on rather than putting them off, because it's always easier to have that conversation sooner rather than when new members of the family enter, new people join the family, founders become older or some crisis event emerges. I think the recent pandemic has been quite an extraordinary example of this, of sort of how crisis can be rather unexpected, and people that clients that carried out advanced planning really saw in a really dramatic manner how this can be the case. And also sort of calm, measured, and rather rational, one hopes, planning early in the day will usually create more longer term and will generate more longer term planning rather than just immediate knee-jerk reactions when you try to effectively just put a plaster on to fix an issue. And another obvious point when you plan early, or early on, is that this creates more opportunities to amend and reconsider the planning that you put in place. If, for instance, you see you have you're not sure it's going to work for the next generation, or more simply the circumstances or the law has changed, or the legal and tax landscape have changed. So putting the planning in place earlier on can allow for time to make those amendments rather than a frantic last-minute rush. Next slide. So I've just summarised on this slide. I think most of you listening can imagine what the critical junctures are, but this is generally the events that trigger. These are generally the events when clients come to see us, and this is when I would say it would be best to preempt these issues rather than use these as an opportunity, as the occasion to come and discuss with advisors. And it's not just discussing with advisors and lawyers, but it's having that conversation within the family. That's the very important thing. So the obvious one is the generational shift. Inevitably is a fact of life. People get older and they need to prepare to, unless the business or the assets are going to be, come to an end, which one hopes not, with their life, one wants to prepare for the generational shift. So that's an obvious catalyst. Another occasion is marriage, when you have new members of the family entering the family. And we've seen a rise everywhere in Europe of prenuptial agreements, which, connected to the second point, obviously, unfortunately, not all marriages are forever. In the UK, for instance, I don't know about the Baltics and Belarus, but in the UK, the rates of divorce are very high. About a third of marriages ends in divorce. So, it's probably best to plan in advance rather than wait for the divorce and deal with it by way of court proceedings and so on. So rather than an acrimonious divorce, there's a lot to be said about a prenuptial agreement before, when you're still in love, one hopes, happy, rather than when you feel that you're at the opposite ends. Family tensions and disputes are a fact of life, in any family. And financial difficulties, it's something that it can be sometimes hard to predict, So asset protection is something really close to the heart of many of our clients. And death, obviously, inevitable fact of life. Carter's given us examples of what happens when people die without a will. And there's a lot to be said. It's already a very stressful moment in life, and there's a lot to be said about planning for that. People we know never like to discuss. People never like to discuss things like death, money, relationship issues. But sometimes a lot of what we do as private client lawyers is managing and more than managing, I should say, facilitating those conversations. And I must say it is a lot more rewarding for us lawyers than litigating or resolving disputes through courts or through more aggressive measures. Next slide. So I've tried to summarize, but the list could be endless. What families generally wish to achieve, what are the general objectives? And, you know, the first one Kat touched on is the obvious one, succession planning. And a lot of what I see, and many private client lawyers see, goes beyond the immediate estate planning and generational planning, and it's more governance, family governance, and this is particularly true in businesses, first generation businesses or businesses which are still family owned. You know, many issues arise. You know, the children might not have the same interest in managing the business, might not be as interested in running the business as their parent, you know, who invested, you know, who set up the business and obviously feels maybe emotionally attached to that business. So so there's a lot to be said about managing how the children are going to be involved, whether non-family members are going to be allowed into the management and ownership of the company. And obviously these are very important conversations to have, because obviously the founder will inevitably feel more emotionally attached than, you know, than a third generation or than a long distant relative. So these are very crucial conversations, and we deal with them in a number of manners, you know, and sometimes and I think Donatas might touch upon it, the next speaker in this presentation, and I know Kat mentioned it, where we see instruments such as family charters and constitutions, where there's a need to actually put something in writing and set out the rules, so to speak. Obviously, tax is an issue in some countries more than other. So, you know, obviously understand the Baltics have, and most countries have, many countries in that area have no inheritance tax, and corporation tax, for instance, is relatively low. So there might be less of a pressure, but things change. You know, taxes might go up, especially after COVID. There's going to be a big bill to pay in many jurisdictions. And families become more international. Families move, and one business or assets could end up exposed to taxation in several countries. So that is definitely something that's still relevant. Asset protection, as I mentioned earlier, is crucial. Business could be very strong for the time being, but there could be problems with creditors. There could be litigation. So often clients ask us how they can protect at least part of the business from such risks. And something that is increasingly important for clients is, and they're not necessarily the most high profile ones, is privacy and reputation management. And we're not only talking about celebrities worried about ending up on the newspapers or their personal affairs ending up in the media. This is much wider concept. It's, you know, how information about the business is managed, and how the risk of this being leaked in an inappropriate manner and used in a way that is prejudicial to the business. You know, we need to, it is crucial to manage that flow of information, because now more than ever in a digital age, information travels internationally very quickly. And so that can, I've seen it be severely prejudicial to many businesses. Next slide. And this is pretty much, this slide is pretty much hand in hand with the previous one. So what the objectives can sometimes turn into challenges, because obviously none of these are easy conversations to have. And so what are the challenges, you know, behind these objectives, so to speak? The first one, which I'm going to concentrate for the purposes of this presentation, is choosing the right structure. Most entrepreneurs, founders, just set up a business or start, begin their professional career, and don't really think about, they just concentrate on their business, on the project, on obtaining finance for it, and they don't really think about how it's going to be handed to the next generation or how it's going to be prepared for further growth. So that is the first challenge and probably the hardest. And because of the limited time for this presentation, it's the one I'm going to concentrate on. The second point is a constant tension in many, especially family businesses, or any situation where wealth is going to be passed down to the next generation, which is protecting the wealth from excessive taxation challenges by creditors, litigation, protecting it from, in case the next generation is not sufficiently interested or prepared to manage that business. But at the same time, something that's an issue that arises time and time again with my clients is the founder wanted to maintain control during this lifetime. And sometimes we have some extreme examples, which I will mention towards the end, there's an expression in English of, we say, ruling from the grave. The founder is so concerned about the next generation and so worried that the next generation is not going to live up to basically and be able to continue the work that she have done, and they end up setting very restrictive rules in relation to the business, which just become too inflexible and too complicated for the next generations, who then feel themselves trapped in this plan effectively. So this is something that is crucial, trying to find a sufficient balance between the desire of the founder not to see all his hard work go to waste, but also allow sufficient flexibility for the next generations to adapt to changing circumstances and be able to continue the work of the founder in perhaps potentially very different circumstances. The third point comes hand in hand. Cross-border succession, forced heirship, I sort of touched on in introduction. Many jurisdictions don't have total testamentary freedom. You have to leave a certain percentage of assets to children, to your spouse. So obviously that's to factor in. And I have many situations where there's a concern about leaving certain assets to a spouse or child, or there's a difficult family situation, or family members has no relationship with the founder or the entrepreneur, and the question becomes, how do we comply with this obligation to make provision and provide for that family member, whilst not risking jeopardizing the business or losing some very valuable assets. The next point, which I touched upon, is another critical juncture is always welcoming new members to the family. That often happens with marriage and relationships. So obviously that's always a trigger for conversation. As I said, unfortunately, sometimes things don't work out and we have to deal with divorce and family fallouts. And the final point is crucial. The world and the law and tax are changing at a pace never seen before. I know this is a very trite expression, but I think it's fairly accurate. If we just think how much tax regimes change very quickly. We've seen how many new tax regimes have emerged in Europe. The UK used to be an El Dorado, a Mecca for many internationally wealthy. This has now become more limited. The so-called resident non-regime, for example, is limited to 15 years now. So countries like Italy, Portugal, and other European countries are really competing in attracting wealthy individuals. So Europe and beyond are changing from a tax perspective at a pace never seen before. And another major change in the last 10 years is transparency. I saw a question on the chat box about reporting of bank accounts. If we just think how much has changed in the last 10 years between US reporting, FATCA, EU regulations, and internationally the common reporting standards, that would have been unthinkable 10 years ago. So things changed at pace, and that is another example of why sort of forward planning and constantly updating one's planning is required. Next slide. So I'm going to go through the next slides quite quickly. They're quite detailed. I made them quite detailed if any of you wanted to look back at them after this presentation and get in touch with any questions or so on. This is not meant to be a lesson or in any way on ownership structures. We would need hours for that. As I mentioned at the beginning, the aim of today is to really give a flavour to you of the kind of conversations that we have with clients. And because of the limited amount of time available, obviously, I just wanted to pick one example, which is how to own assets and wealth. And as I said to you earlier on, clients often are so often concentrating on just starting a new business, accumulating wealth, and they usually resort to very straightforward solutions, if at all, that if they think about it in the first place. If they do think about it, and will simply keep assets in their own name or hand some over to family members. If we're lucky, they might write a will, but there's very little sort of more sophisticated planning very often, especially at the first generation. So I just wanted to really touch on some examples on some structures that we commonly see. And something I just wanted to mention, I know Kart mentioned, something that's become increasingly popular, that in order to help clients think about generational planning and manage their wealth, is the use of family offices who work hand in hand with advisors like lawyers and others. And they don't have to necessarily be single family offices. That's usually the case with very sort of particularly wealthy families. But there are there's an increased number of multi-family offices that serve a greater number of families that assist. If we can go on the next slide. As I said, the most common ownership mechanism for most entrepreneurs and for most first generation family-owned businesses is direct ownership of assets in sometimes in multiple jurisdictions, which leads to the complications Kart mentioned. And if we can go on to the next slide, this is the easiest way of holding assets. There are no additional costs. There's psychologically there's a perception of direct ownership and of simplicity, but simplicity this can be pretty much a false sense of simplicity, because as you can see, the disadvantages column, it way outnumbers the advantages often. Owning everything directly creates complications further down the line in the event of succession. It will be way more difficult to reach family consensus. You will require to effectively manage the transfer to the next generation. You will be needing wills, potentially several wills if assets are in several jurisdictions, like Kart mentioned. And you will have in most jurisdictions very little asset protection and limited ability for tax planning. So whilst it's an immediate way of holding assets, direct ownership often has fairly limited benefits. Next slide. The next two slides are the slightly more sophisticated ownership structures which we see. The first slide is what we see most commonly for first generation businesses. So if there is a business involved, and it's not a question of owning assets directly, there will just be one company, one country owning the assets, owning the business, and obviously there will still be a concentration of powers at the level of the owner. If you can go to the next slide, Ineza. And obviously things become even more complex at the second generation stage, as and when, if one sticks to the corporate vehicle ownership structure, things can quickly become rather complicated the moment that the number of family members involved increase, and you end up with a fragmentation of ownership. And the more ownership becomes fragmented, the more you lose control. And if we can go on the next slide, if you just allow, as generations continue, for the involvement for the number of shareholders and potentially directors of companies to just increase without any kind of control over this, you will end up in a position, even in the most harmonious of families, where consensus will just become impossible to achieve just because of the number of people involved. And any shareholder agreement or partnership agreement is going to become increasingly more complicated. Whilst there will still be some advantages to direct ownership, for instance, succession will become slightly easier because you will be dealing with shares rather than individual assets. You will still be left with possibly less succession issues, but definitely a great number of governance issues, as well as potentially asset protection issues. Next slide. So two other examples I just wanted to give you are more complex structures, which many clients of mine have used and have adopted because of the flexibility they offer. And these can be used in a structure on top of companies, so they don't necessarily have to be a replacement, are foundations and trusts. And foundations are, generally speaking, more popular in civil law countries on the continent, Switzerland, Austria, and so on, because it's effectively a civil law concept, whilst trusts are a common law concept typical of England, for instance, that is not present in many civil law countries. But many countries, even though they don't have their own trust law, will still recognize trusts. And even when there are countries that do not recognize trusts, they might still be attractive, as I said, not to hold assets or shares directly in that country, because you will have obviously issues with recognition, but at a higher level in the structure. And this can become particularly useful where, for instance, family members and assets are situated in multiple countries, because both foundations and trusts give you a level of flexibility that companies and definitely speaking and definitely direct ownership would be able to offer. So as I said, you can look at it in your own time. I just try to summarize the difference, how a foundation and trust will look like. Both foundations and trusts, if you can just go back 1 second, something I would say both in relation to foundation and trust is that any governance mechanism is really important to work it out early in the day. And this is why I always recommend having this conversation very early on, because it's going to be much easier when there is consensus at a family level. So what I always say to clients when they're looking at a more sophisticated structure like a foundation or a trust is, set out the rules and agree the rules where the family is still quite compact, the business is still in its early days perhaps, but then allow sufficient flexibility to amend those structures further down the line. Because trusts and foundations, by their very nature, unlike companies, can last multiple jurisdictions. Some have been in place for decades. Next slide. Actually, if you can go to the next one. And this is the just like I did for foundations. I just tried to represent graphically for your benefit how a trust will generally look. If you can go to the next slide. This is pretty much, as I said, for foundations. Both for foundations and trusts, the main advantages are, as I said, the incredible flexibility, the ability to set the rules, the ability for the settlor or the founder to establish some rules very earlier on, the ability for them to work and manage wealth across jurisdictions. Confidentiality is obviously another issue, but the reason why these instruments remain very popular, despite the fact that, for instance, they don't offer the tax protection they used to in the past, is their incredible flexibility, and that's the main reason why they're still used by many families, especially international families with members situated in various jurisdictions. If you can just go on to the next slide. As I said, because of limited time, I really have to run through the ownership structures, but I wanted the slides to be a bit more detailed than I would have been able to cover speaking. And I'm very happy to take any more detailed questions from you at the end of this presentation or later in private, because I realise there's a lot of food for thought in this presentation, hopefully. I try to summarise on this last slide before I hand back to Kat and we go on to the next presentation, some key points that I would like the listeners to take away from this presentation, and just sort of perhaps hopefully sort of trigger reflection and trigger a conversation within the family and with their advisors. As I said in the very first slide, I cannot stress enough the need to plan in advance, way before issues arise. It's a lot more pleasant to for prevention. Prevention is better than cure. There is such an expression in most languages, and this is really the case. As I warned earlier on, avoid a temptation for founders to rule from the grave. Obviously, there's a great emotional attachment to what you've created, but sometimes that lack of flexibility can not just be limiting on the next generation, but can really compromise the development and growth of your business, especially if circumstances change dramatically. No one can know what the world's going to look like in 10 years, if not 50. So, really resist that temptation. As I said, don't avoid those difficult conversations. Conflicts are a fact of life. They can't always be avoided, but they can definitely be managed. Engage the next generation. As I said, really avoid the temptation, as I said earlier about avoiding the temptation to rule from the grave. Give sufficient flexibility to the next generation to encourage that owner mentality. If you do give that flexibility and you do give that power, usually next generations will feel more motivated and encouraged to build that business or preserve that wealth at the very least. Don't be so resistant to outside intervention in businesses. In first generation businesses, I often see a strong resistance. As I said time and time again, there's an emotional attachment to the business. So there's a real, I don't want anyone new involved in this business. And sometimes you do need those external members, which can be advisors or involved in governance, to bring in those fresh ideas and help the business not just survive, but also thrive and grow. And as I said, earlier in this presentation, do not forget, as well as the obvious asset protection and tax, do not forget the reputational elements. It's incredible, especially in the modern age we live in, how a company, a business reputation is everything. Information can travel very quickly. We're not in the era of newspapers anymore. Things can travel over the internet very quickly, and it's incredible how misinformation and the wrong use of information can really undermine a company. So that is something to really bear in mind in all of the planning that one does. Thank you very much. I realize it was a very sort of quick very quick sort of run through a very wide number of issues. Very happy to take questions, and I'll now hand back to Kat, who's going to introduce our next speaker.